Good morning, everyone, and thank you for joining us for today's Workers' Compensation 202 webinar. I'm Jen Donovan from the board's Stakeholder Engagement Unit, and joining me today is Joe Cavalcante, the board's advocate for injured workers. Today, Joe will take a deeper dive into best practices workers can use to access their workers' compensation benefits, including understanding labor market attachment, details on benefit periods and how benefit rates are calculated, the importance of items such as the degree of disability and the carrier continue payments order, how advocates can help workers and comply with privacy provisions, and the Workers' Compensation Board's New York Medical Treatment Guidelines. We will be taking your questions via the chat today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joe will answer as many of your questions as he can, but if there are any that he doesn't get to, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with your contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are configured so that only panelists can see any questions or comments that come in, so you do not have to worry about others seeing your contact information. And with that, I will now hand it over to Joe and we will go ahead and get started.
Thank you so much, Jen, and happy Halloween, everyone. Thanks for those of you who came in costume. We'll be doing our costume awards in the third half of our program today. Also, thank you so much for the questions that you all posed when you signed up. When you give us those questions, that tells us what you're interested in. And sometimes I might need to look something up before we come on. But for today, I can tell you, we will be covering just about every question as part of the regular program, but always feel free to ask us something in the chat feature. So we're going to begin with, who is this advocate for injured workers? Well, technically it's me. I am technically an ombudsman. That's my real civil service title. That means that I'm concerned with the health and the sanctity of the workers' comp system. But I come at it from the perspective of, how is it working out for injured employees? We do have an advocate for business as well, my brother advocate, and the two of us do these webinar trainings. So you might want to sign up for the advocate for business training as well if you're interested in that. But for my role, I have an office of dedicated people who help workers with the more difficult and complex claims. We try to help them access their benefits. Our office also handles fatality claims, and I am the board's primary liaison to the 9/11 community. Now, the 9/11 community, well, I have to tell you, that situation is ongoing. Okay, so we deal with 9/11 every day here at the board. So if you can be supportive to a responder, that's always appreciated. And also, this is just a moment where I can remind you that if you did do rescue, recovery, and cleanup at the World Trade Center, you do want to file a form with us called the WTC 12, and that preserves your right to file a claim in the future if you should ever need it. All right, so let's move on now to education. We have education. Jen and I have been deeply involved with that list you see on screen of publications for workers. So you can come to our website. Your link is there on the screen, and you can go to publications and you'll see all these publications for workers, but you will also see publications for employers and other system topics. It's relatively self-serve, but these are all written in a very easy to understand, intelligible manner. I promise you that, because Jen and I worked on all of them. Okay, so let's talk now. You're a worker, you have a claim. Do you have access to your claim folder? Can you see all of the documents in your file that everyone else sees who's part of the system? If not, why don't you register for eCase? Then you can see all these documents. We are showing you on screen right here the eCase registration screen. Essentially, if you come to our website, at the top, one of the 5 links across the very top is going to say eCase. Just give it a click and you can register and you can then get access to your claim documents. It's a form of empowerment. It's a form of education. I recommend it heartily. Let's now talk about the privacy provisions of our system. This is something that is important for people who wish to help injured workers, advocates. The privacy provisions of our system, they're for our system, okay? They limit the people who can get claim details from the board to, you can see the parties on screen, the workers and their attorneys, yes. The employer, yes. The insurer, who's going to pay the claim, yes. Their attorneys, yes. And providers, we can discuss details with providers in circumstances. Everyone else, the answer is no, we cannot. And that could include well-meaning advocates. So the worker can grant access to claim details if the worker completes that form whose name you see on your screen there. It is known in the business as the OC 110A form. And the reason is because, to give you the background, even though there is a HIPAA law and even though there are other laws around healthcare, the workers' comp system in New York is actually under the jurisdiction of Workers' Compensation Law Section 110A, hence the name of your form. So once the worker fills that in and names somebody as able to hear or eligible to hear claim details, it'll go in the file. You have to send us the paper, and then we can discuss claim details with the person the worker has identified. You can do it, you can fill it in online, but you're going to have to print it and mail it in the US mail. We also have it readily available in Spanish, because more than 3/4 of our translations are Spanish. Okay, we're going to start getting into the claim benefits, the claim flow now. With also good, helpful background info, I promise you. But now you can use those elements to start to understand your claim if you're a worker. The first topic is controversy. This is when the insurance payer is formally disputing or controverting, as we say, formally disputing or controverting the claim. That means they're arguing that they should not have to pay benefits in this claim, and until this is resolved, they will not be paying benefits in this claim. So that means if you're a worker, you're not going to be receiving any lost wages if they were due. You can be controverted on a claim where there's no lost time, no lost wage. But if you are missing time from work, you're not going to get your lost wages. And also, if you are a healthcare provider and you're authorized by us, you do have to treat those patients. That's part of your authorization, even though this is controverted, even though you shall not be paid for your services until the controversy is resolved in favor of the worker. But yeah, you do have to treat. This person still needs health care. So the insurers will cite one of a limited number of reasons. They can't just say whatever they wish. There's a limited number of reasons that they can cite from to controvert. And then it is probably going to go on the expedited calendar that will resolve it in probably 90 days or less. Now, some claims are too complex for the expedited calendar. Those are typically occupational disease claims, so they wouldn't be on that 90-day calendar. But we do try and get this resolved in 90 days or less. And if you are a worker and you are missing time and you have no income, you may file the claim for short-term disability. That's that claim form name in green there, the DB 450. Typically, you can't receive both short-term disability and comp at the same time. However, you're not actually receiving comp right now, but we know you can't work, so you can file the disability claim. You can get some income at $170 a week. That's the number that's fixed in the law, my friends. And when it's resolved, if the claim is not established, well, you just keep the disability. If the claim is established, that means that it is now payable under comp, and the disability insurance company and the comp insurance company will talk to each other and they will exchange funds. They are very good at this. There is an element in our system known as the CCP, Carrier to Continue Payments. We'd like to speak about this for a moment because sometimes workers are in front of judges and the judges will give an order to pay benefits and they will say also carrier to continue payments. That means there's an ongoing disability. Someone is still injured, still can't return to work, and the judge is saying carrier continue payments at this amount, and there will be a dollar amount there. So then that means the insurance payer may not change that without further direction from the board. So if a judge puts in a CCP of $1,000 a week, that means the worker shall receive $1,000 a week moving forward until the point when the worker either comes back to work and somebody makes a move to stop the CCP, or you have another hearing and the judge or an appeals panel revokes the CCP or stops the CCP. Here is a new topic, but we're going to spend a few slides on this one because this is so very important. If you're an injured worker and you're receiving payments, what are your payments based on? Where does that dollar amount come from? Well, first place you need to understand is how disabled you are, what's called your degree of disability, or the technical term is actually temporary impairment percentage. But I'm going to call it degree of disability because that's commonly used and it's more intuitively obvious to everyone what that is. You see this table on screen? Okay. When someone is injured, the treating provider is going to indicate the percentage of their degree of disability. It shall be expressed between 0% and 100%. 0% disability means you're well, you're healthy. Okay, that's great. But it ranges all the way up to 100%. 100% disability means you can't work. All right. That's the first element you have to understand. We put this table up because we wanted to show you also on the left, those are the standard English terms that used to be very common in our system, but they're still used by a lot of people. So total disability means 100%. Marked, moderate, mild. Those are the ones you frequently see. And marked 75, moderate 50. Okay, you might see those terms. Those are the percentages. They mean everyone in the system knows that. And by the way, the degree of disability can be any percentage. It can be 33 or 67% or anything else. It's up to the doctors. Now, how does this play out in terms of your benefit? Here's how. If you are totally disabled, 100% disabled, you're going to receive 100% of the benefit rate. So let's make an easy math example. You earned $900 a week. That was your average weekly wage. So your benefit rate maximum is 2/3 of that, 600. Okay, 600. You're totally disabled, you're getting 600. If you're 75% disabled, you're going to get 3/4 of that, which is $450. 50% disabled, you're getting 300, half of the 6. So you see how that math works? So this is what we are showing you here. And I'd like you to also remember the maximum benefit you're going to get is always capped by your date of accident. So that means whatever maximum amount was in force when the day you were injured or disabled, that's the most you can have. So if that was 10 years ago and the maximum rates have risen in 10 years, and they have, I'm sorry, you're still capped at the maximum on the date you were injured. And now we're going to have the first word from Jen.
All right, everybody. You should see a poll on your screen. Shoot me a note in the chat if you don't, but we're gonna chat about Susan for a moment. Susan was 100% temporarily disabled and has been receiving $1,000 a week for the last 3 months. Susan's doctor recently said she is healed to the point where she is now only 50% disabled. Susan has never had a workers' compensation hearing, true or false. Because of her new disability percentage, Susan's benefit rate will now decrease to $500 a week. So go ahead and let me know if that is.
I'm going to give you a moment.
Give you a moment. All right, some results are coming in.
Answer our poll.
I see a lot more true than false.
All right, we're going to give you another moment. I'd like to see at least half of us reply. So let's do some clicking, folks. Is it possible for Susan's benefit rate to now decrease based on, I'll give you a hint, based on that 50% disability? All right, I think that's over 50%, John.
Mm-hmm.
Okay. We do have a difference of opinion here. And I wonder if I didn't stress one or two things hard enough. Here we go. I'll walk through it with you. She's 100% temporarily disabled. Okay, so she's temporary. This is the part of the landscape where that degree of disability ongoing is so important. So she was getting 1,000 a week. That's 100%. So her doctor now says she's 50% disabled. All right, that's her degree of disability. Remember I indicated that if you're 50% disabled, you're eligible for 50% of the benefit. So that is why her benefit can easily and will almost certainly be reduced to 50% because Susan has never had a workers' compensation hearing. So that means she's never seen a judge who could have put into place a carrier continued payments order. So remember I talked about that? Well, that's not in this claim. We didn't tell you it was. And the little clue we gave you was she never had a hearing, so she never saw a judge. So of course it's not there. So yes, she's 50% disabled. So her benefits will now probably drop to $500 a week, 50% of the rate. Thank you everyone for participating. We will have another one later on. But this now is the last major topic on degree of disability, but boy, this is an important one. If you are from a medical provider's office, number one, thank you for coming. Number two, thank you for treating our injured workers. Number three, please pay 100% of your attention to me for the next 2 minutes. This is solely for your benefit, and it is so important. When you, as a provider, see an injured worker who is temporary, okay? Remember Comp 101, all injuries are temporary unless they become permanent. So we're in temporary world here, which is the vast majority of claims. You're going to have to file with us in order to get paid for your services. Number one, a CMS 1500, the Universal Billing Form. Okay, great. But now, because we're comp, you need one extra thing. You need to answer these 3 questions. Number one, is the patient working? Number two, Causality. Is this condition that you're treating right now the cause of disability? And then finally, number 3, how disabled is the worker, the degree of disability? So how do you do this? Well, you know how to do the CMS 1500. You are now going to answer these questions one of 2 ways. You're either going to attach probably your treatment notes. Here's a request from me to you. If your treatment note template does not already include these 3 questions, please include it today so that your providers never, ever, ever fail to answer these questions. If you don't wish to do that, but you wish to use the simple report template we created for you so that you could file these easily, on screen you'll see an image of the medical narrative report template that we created for you. You certainly can download this from our website. You can certainly incorporate it, and you can see the top section has all that demographic info that you're used to providing, and the bottom, those 3 huge blocks: work status, causal relationship, temporary impairment percentage, the technical term for degree of disability. Jen gets 100, by the way. She was totally on that. Okay, so would you please be sure to always answer these questions every time you're treating someone who's temporary? And if you're a worker, you may certainly ask your provider about this, and you should certainly try and understand it. Thank you very much. Now, moving from temporary world to permanent partial disabilities. Do a little permanent partial now, because it is possible for someone to heal to the point where they can't heal 100%. They're going to have a permanent partial disability. That means that they are less than 100% disabled. That's the partial. And we are now showing you the chart on screen that explains the number of weeks of benefits the worker shall receive for a permanent partial disability. This is known as PPD in a system that is infatuated with acronyms. You will hear PPD. This is what we're talking about. Now, speaking of acronyms, on the left, you see LWEC. That means loss of wage earning capacity. We all have a capacity to earn wages. If you're perfectly healthy, it would be 100%. However, permanently partially disabled, you're going to lose some of your wage earning capacity. In the system, we call that LWEC. If you ever hear LWEC, it means loss of wage earning capacity. So, to determine the benefit amount on a PPD, permanent partial disability claim, there's a calculation done that creates the worker's loss of wage earning capacity, and each one maps over to a number of weeks of benefits. So you can see the very bottom, from 1 to 15% wage earning capacity that's been lost, you'll get 225 weeks of benefits. And that goes all the way up to the top level, 96 to 99, which is 525. So we've done the math for you. That is between 4 years and 10 years of benefits. And then when that's done, except, let's say you're a worker on a PPD claim. Let's say you're a provider who's treating a worker on a PPD claim. Let's say you're an attorney who's representing a worker with a PPD claim. Suppose the worker's health deteriorates over the course of that claim. That is certainly possible. People can get less healthy, especially if they're dealing with a permanent partial disability. So, if that should happen, the worker may try to demonstrate a change in condition. And if that change in the worker's health condition makes the worker 100% disabled now on a permanent basis, they can pursue a reclassification to permanent total disability. That will change the benefit amount, the highest amount possible, and that's a benefit that's payable for life. Now, the other thing workers may do in a similar case is take advantage of a vastly underutilized benefit known as total industrial disability. This also indicates a worker cannot return to labor and should qualify for the maximum benefit the worker is qualified for. Total industrial disability has slightly different conditions than permanent total. There is a place to consider the worker's educational level and facility with English and realistic possibility for retraining into other employment and so forth. I say it's vastly underutilized because in the year 2023, in a year when we touched over 250,000 claims, 7 people got total industrial disability. 7. So if this is you, or if you're an attorney representing injured workers, I bring these two benefits and this road to your attention. Now we're going to talk about, for a moment, a best practice for indemnity payments. We have best practices for workers, and then, surprise, surprise, we added in best practices for payers that you'll see in a couple of slides, but you're going to have to take a quiz first. All right, so here are the best practices for workers with indemnity. Number 1, would you please, 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 if you can get a bank account, would you please consider using direct deposit? I don't know what else I have to say about this. You realize you can't even get a Social Security check anymore unless it's directly deposited. If you're an injured worker, why on earth are you getting paper checks if you can have a bank account? Thank you very much. Number 2, if you're paid in cash for your labors, that's fine. Cash is legal tender. It's just that you might wish to keep a record. You might want to get a notebook or use one of your many electronic devices, and please just note how much you got paid, what day, who paid you, what did you do to earn that pay? Because if you have a comp claim, of course, cash counts in a comp claim. It's just that you now have what's known as a contemporaneous record of payment. Do I need to explain how important that is? And then also, please note where you were working when you got injured. Okay, so for most of us, that's relatively simple and easy if we go to the same workplace every day. But let's say you don't. Let's say you do construction. Let's say you're in a city, or let's say you travel as part of your job. It's lesser important on that one. But the point is, when you do construction, particularly if you do day labor, particularly if you represent workers who do that, there might be a dispute about who the correct insurance company is because there are so many different insurance companies on a construction job because there are contractors and subcontractors. Well, pay attention to the address. If when you file your claim, please put the address where the accident happened, so then we could just pull the building permit. And if we pull the building permit, we will know pretty much everything we need to know about who the payers are in the mix here. Thank you very much on that one. This is a very big topic now. We're going to spend probably another 10 minutes on this one topic known as labor market attachment. I shall now simply explain to you what it is and how it works. We're still in temporary world now. That means we're dealing with a worker who is temporarily disabled at less than 100% disability. So technically that would be called temp partial. Remember we had permanent partial? Well, temp partial, temporary partial disability, because you're less than 100% disabled. there is an imperative on those workers who are temporarily partially disabled to possibly seek employment within their restrictions. That means that the insurer might be at a hearing. It's definitely going to happen at a hearing, but you might have a hearing, you're temporary partial, you're a worker, and the insurer asks the judge to consider the question of labor market attachment. So this is assuming the worker is temp partial and not presently at work. Okay, so you're getting 75%, maybe 50% benefit. Maybe you were 100 and then there was an independent medical exam that had you at 50% disabled. So now the judge says, okay, I'm putting you at 75. These are things that happen. The insurer can ask the judge to ask you to demonstrate labor market attachment. That means you now have to seek employment. Workers in our audience, you're going to have to do a work search, and you're going to have to do it in a timely, a diligent, and a persistent manner. You see those terms in green there on the third bullet? Those are the three most important things to you right now if this is you. You have to do a timely, diligent, and persistent work search. So the type of the work search is known. It's just that, well, you might notice those are all subjective words. So there's nothing objective attached to them. So we don't have any numbers or dates to give to you. So the amount of effort is going to be decided at a hearing or upon appeal. So that means like a judge or a board panel, if it's appealed, is going to decide whether the work search was sufficiently timely, diligent, and persistent. So now you have to do this work search, and you're going to have to document your work search activities. Okay, how do you do that? What form do you use? Where do you go? Well, the court decision that is driving most of this is known as American Axle. That's what they call it. That's the name of it. And so in American Axle, these certain elements that are on screen for you were laid out by the court as, helpful or demonstrating labor market attachment. So that means you're a worker, you certainly may use the Department of Labor, State Department of Labor, reemployment services. You can certainly go to the Department of Labor one-stop centers, and you could do your searching there, and you could do follow-ups, and you can avail yourself of their services. Please do. You can take seminars and orientations, counseling, voc rehab. You can have vocational rehab counseling via Access VR. If you're an old timer like me, you might have known it as VESID. Now it's Access VR. You certainly may use those services to help with your work search and your trainings. You may also go back to college or go to a trade school. If you do that, that could potentially meet this labor market attachment imperative. So you graduated high school, you went into the workforce, now you're very disabled and you have to look for work. If you feel like you want to go to the community college in your area and fill out a FAFSA form like parents of an 18-year-old do, so you don't have to pay for this right away, go on ahead. You can use that to try and meet this. Now, you're going to have to document it. So we are showing you on screen a form known as the C-258. You can do this freehand if you wish, or you can use this form that we created for you. Fill it in as many times as you need, and be sure to send it to the board to get it in that file of yours. You can use eCase to check on what's in there. And also, here's a special tip, include a resume. Get a copy of your resume into our board file, please. Now, those were resources that you can use to help demonstrate your attachment. They might put you onto a job, but you may also do an independent work search. That means you're looking for the job by yourself. And You certainly can use all of the tools that are prevalent today in work searches, such as LinkedIn or Monster or Indeed or Glassdoor or any of those online things. If I'm missing one, you just type it into the chat, okay? But you can certainly do your own work search and you can do it online. But here's the thing, you know how when you do an online job application, you're probably replying to maybe a posted job and it'll have a job number and it'll have a web page address or a URL technically. Capture that, okay? Because we have another form you're going to use known as the 258.1, C58.1, we're showing you online. You can use our form or you can do this freehand if you wish. I recommend that you use the form. And you need to cite all these details, okay? You need to tell us when you did it, what day, you know, and who you spoke to if you spoke to someone. Did you have an interview? My goodness, put that on there. But if you applied for jobs based on internet postings, you need to indicate the web page. You need to show a timely, diligent, persistent work search. Take it very seriously. Give us all the details so that everyone can see how diligent and persistent your work search was. And do it regularly. You know what they say? If you want a new job, make looking for a job your full-time job. Well, maybe do that. And then you're going to get all these in your file, and then you'll have a hearing, and the judge will review these and make a determination. So that is how labor market attachment works. Now that I've given you all of that background, Jen's back with another quiz.
All right, so we're going to chat about Willie. Willie was 100% temporarily disabled per his treating physician. There's just been a hearing where an IME opined Willie is 50% temporarily disabled. A judge has just decided Willie shall receive benefits under a CCP at 75% disability rate. Can the payer now ask at the same hearing for Willie to demonstrate labor market attachment? So I see some answers coming in already in our poll. We've got a lot of yeses, a couple no's. We'll give everyone just another few seconds to type in your answers.
And Jen, let us know when we should forward, please.
Okay, give everyone another minute. We have a majority of yeses, 5 no's.
All right. Those of us who indicated no, I would be really interested if you would type into the chat why you selected no. The answer is yes, the payer may, at that hearing, ask Willie to demonstrate labor market attachment, and the judge could consent to it. Yes, because this is actually the example I gave a moment ago without realizing that this was the quiz. But I guess we're right on track then. So yeah, Willie is no longer 100% disabled, and he's temporary. So now he is what we call temp partial. So yes, the minute that judge changes to temp partial, absolutely, if there's a payer there, they are within their rights to ask for labor market attachment, and the judge can grant it. So yeah, Willie will now have to go through this exercise. We are now going to give you some of our new updated content. We had a big conference here about 12 days ago, and we had some presentations, and the head of the agency, the chair of the agency, liked the following 2 slides so much that she asked me to include them in this. So here you go. This is a best practice for payers. If you are a payer, I'm sure I have your attention right now, and thank you. Thank you, thank you. I'm always happy to talk to payers. If you're a worker or a doctor, you should be paying attention because this pertains to you too. Number 1, 21A. There's a section of law known as 21A, and it's also known colloquially or nicknamed pay without prejudice. That means that the payer can begin paying benefits, but they haven't formally accepted the claim. It's not formally been established, but they are paying benefits. That's great. Just reminding all the payers out there, because a few of them kind of need this reminder. The payments have to be consistent with the medical reports that you have and the wage information you have. What does that mean? Well, if there are medicals in there that say 100% temporary disability, you should be paying at the 100% rate. There's no argument there. If you have wage information, like what the worker was earning, you can calculate that 100% rate, and you need to do that. Even if you don't have the C-240 form, which is the form that is used to file that info, you're still not allowed to pay the minimum. You have to come up with the proper rate if the medical reports are clearly saying temporary, total, which is why it's so important, doctors, that you indicate a degree of disability. And you're 21A, so you accepted it without liability. So the trade-off is you need to pay the full temporary benefit. Here are some more best practices. Sometimes we have depositions in claims, in hearings. Sometimes, usually it's a doctor or a healthcare provider who has to do a deposition. Well, there are fees attached to those depositions. They're set already in the law. Like a physician will get $450 for a depo. It's set. Okay, payers. You have to send the $450 within 10 days of filing of the deposition, period, end of story. You do not need a judge to tell you to do this. You have to do this, okay? We announced this recently, and we're going to hold everyone to it. Depositions filed, please release the fees within 10 days of filing. This is me saying thank you. Also, if anyone is requested or ordered by a judge, depending on how you want to look at it, to submit a summary of payments before the next hearing, submit it before the next hearing. We announced recently that if we're asking you to do this, we really wish that you would do this. And then finally, another best practice, this one pertains to payers again. In a medical-only claim, med only, no lost time, but the worker got medical care, because every claim is going to have medical care or some sort of health care. If that med only claim was not indexed, if you're in the system, you know what indexing is all about. If it was not indexed, and it might not have been, if the worker starts losing time, it's going to become indexed. So once we index it, you payers, now you're going to have to update your filings and decide on liability if you haven't done it yet. We're just reminding you that this could happen, and then it puts the claim in a different status, so you're going to have to take some actions. Thank you for your attention there. Those are all things that will just make a more smoothly functioning system. All right, we're going to switch over now to medical care. We're going to speak now about the medical treatment guidelines, because we do have medical treatment guidelines. We have 16 of them right now. So the treatment should conform to those guidelines. And the guidelines sometimes require a prior authorization request. We call that a PAR, P-A-R, prior authorization request. Okay, here's what you need to know, my friends. Number one, it's the providers who file for those authorizations, not the workers. Workers, you are not involved in this process. You're off duty here. Your providers take care of this. And they will use Onboard, the computer system that we have, to do this. Now, you might be specified to ask for prior authorization in a few instances. For example, medication. There are some instances where if you want to use a medication for a certain diagnosis or treatment, you're going to have to ask for prior authorization. That's called the formulary request. There are also some treatments that the providers may wish to do that vary from the guidelines. That's okay. It's called a variance request because you're varying from the guidelines and you're going to have to ask for prior authorization. Also, if treatments are more than $1,000, the providers will have to ask for that prior authorization. Now, there's a review process. I'd like to show you the review process now, and we're going to consider the treatment versus the drug formulary process. Let's say the variance or the prior authorization request is for treatment. Okay, remember, it's varying or it's over $1,000. There are 3 levels of review. Level 1, now this is at the insurance payer. The request is going to go to probably a nurse at the insurance payer who's going to review. And if it's approved on level 1, great, go get your treatment. In your file, you will see MG-L1. Okay, get your e-case. There you go, MG-L1. Now, let's say it's denied. If it is denied by that nurse for whatever reason, it is automatically, no one needs to do anything, escalated to a physician at the payer. That is now level 2, L2. And if that physician approves, great, go get your treatment. If not, let's say that physician denies, there will be stated reasons. Now it's back with the treating provider. Not the worker, but worker, you can ask for this from your doctor. The treating provider is going to read what was stated. And treating provider has a choice. If the explanations indicate the treating provider needs to provide something else, well, you can just file it again at level 1. That's perfectly fine. And it very possibly may be reviewed. It will be reviewed. It might be approved at level 1. Okay, great, do the treatment. Let's say the provider, though, reads everything and says, they're wrong. I disagree. Okay, the provider can escalate to level 3, wherein it will go to the board's medical director's office. They will review it. We have medical staff who will review it, and then on level 3, they can approve it, get your treatment. Or they can deny it, and then they'll explain why, and the cycle can begin again. Now, we're going to contrast this with a medication because there's a slight difference in the process I want to call out to you. Level 1, again, probably it's a nurse at the payer who's reviewing. If it's denied at level 1, in this case, the prescriber has to ask to go to level 2. And so when it goes to level 2, it will go to a physician at the payer. And if the physician denies, well, they can ask for level 3 review. And again, that's the medical director's office. Okay. And also just a word to our friends in the payer community. If you're approving the drug, please make sure you tell your pharmacy vendor to tell the drugstore to dispense it. That's a natural chain of events, my friends. It's approved. It should now be dispensed. Thank you for indulging me. Now, let's return to a topic we do in the 101, but it's worth restating in this one because it is such a worth restating topic. The independent medical exam. It is possible for the insurance payer to ask the worker to attend what's known as an independent medical exam or an IME. If you ever hear IME, that means the worker is being asked to see the insurance payer's doctor. They hired a doctor to give, it's almost always a physician, okay? You could go to a psychologist, a PhD for a psychological thing, but other than that, it's almost always a physician. And here's what we need to tell you. Number one, there's no doctor-patient relationship, none. That means anything you say can and will be recorded on that report. You may bring a witness. If you're a worker, you may bring a witness. This is me telling you, you can count on this. Also, you don't have to announce ahead of time that you are bringing a witness. So, to my friends in the payer community, would you please let the doctors in the offices you're using, let them know for real. People don't have to announce that they're bringing witnesses. They don't have to announce they're going to videotape. I'm only saying this because I've gotten 6 complaints in the last 2 weeks about this very thing. Thank you again for listening. So, you're a worker, you can bring a witness. Your witness, or you, seems like a good idea for the witness, may record this. You don't have to bring a camcorder anymore. You can use that cell phone. Video and audio. No one can tell you no. Repeat, no one can tell you no. And you recorded your exam. Okay, why did you do that? Well, you might like the, the procedural safety of it, but also you're going to get an IME report. The board's going to get the report, the payer, and the worker and worker's attorney, if there is one, are going to all get this report. So you certainly may contrast what's in the report with what happened on that videotape. And if there's a discrepancy, well, number one, if you have an attorney, tell your attorney. Because the attorneys do enough of these that they understand what goes on in certain medical exams more than lay people do. So they might say, no, here's where that finding came from. Okay, great. But let's say nobody knows where this finding is coming from in that report. Well, you can make a complaint to the Advocate for Injured Workers. Remember them? One of the things we do in this office to protect the health of the system is we receive these reports and we read them and we triage them, but just about every single time they get passed on to the health provider discipline unit, and those good people examine these complaints. And I can tell you that individual physicians have been removed from the IME system for being naughty here. An IME entity lost its license for being naughty here or not complying with the laws and the regulations. So we do take this seriously. You would send us a complaint about conduct. This is conduct. Also, if you're not examined in a medical facility, if it doesn't look like a doctor's office, you shouldn't be examined there. If you're in a wheelchair and they can't get your wheelchair in the exam room and they have to examine you in the waiting room, you need to tell me about that. That happened. Okay. And also, one other thing to remind everyone, you may claim travel reimbursement costs to and from an IME. And for the distances I see workers asked to travel, yeah, that can add up. So this is my plea to the payer community. Please, if you're going to do an IME, maybe let's get it as close to the worker's home as possible. These are people who are suffering disabilities. Travel becomes difficult. Appeals. This is a new topic. We only have 3 more topics, my friends, and then we're going to do questions. So start typing. But appeals, this is a big part of the system. It is possible for either party, the worker or the payer, it's possible for either the worker or the payer to appeal a judge's decision. That's what gets appealed, a judge's decision. Or a board panel decision. I'll cover that in a second. So, judge makes a decision. You're going to get a piece of paper known as a decision, notice of decision. Or if you're looking at your file because you got eCase, you can sort it to find all the EC23s. Those are the decisions. That's what we do internally, a little inside baseball for you. So on that notice of decision, lower right-hand corner, there's going to be a filing date. It's going to be 2 or 3 days after the hearing because it takes, 2 or 3 days to actually type it up and get it prepared and send it out to you. You have 30 days from that filing date to appeal. If you're a worker and you have an attorney, your attorney does this. You don't do this, okay? If you're a payer, you're going to have an attorney that your payer attorney will do this. All right, so now we get the appeal. The other side has 30 days to rebut it, as in give their side of the story. And we have forms that get used. RB 89, RB 89.1 is the rebuttal. Now, it's going to go up to a panel of 3 board members. Remember, we have 13 people who sit on what's known as the Workers' Comp Board. Well, 3 of them are going to work with the appeals unit here, and they're going to make a decision. Now, if you're a worker, here's what you have to know. If the judge awarded you benefits, the payer does not have to pay you those benefits while the claim is under appeal, if it's under appeal. They don't have to pay until, if and until, a board panel says, yes, please pay these benefits. Okay, at that point, yes, benefits must be released. And except for one instance in my experience here in all these years, the payers all know this and they all release the payments. But it is possible to appeal to the full board. Now, that comes in 2 varieties. Number 1 is a mandatory appeal. That means the board, the 3 panel members were split 2 to 1. So if it was 2 to 1, that becomes a mandatory. And that's going to probably go to the full board. The other one is discretionary. Let's say the 3 panel members all agreed, but one side still doesn't want to accept this and they want to appeal again to the full board. Okay, the full board will get that appeal and they will decide whether they wish to hear it or not, right? Because they don't have to. Now, the next legal body in place to hear appeals is the New York State Supreme Court, the Appellate Division, 3rd Department. So everybody must go to the 3 panel members first. If you don't like it, if you disagree with the decision and you want to appeal it again, you can skip full board and go directly to the Appellate Division. It's just that practically everybody goes to the full board because we are free, and the Appellate Division does charge a fee of some sort to handle that appeal. But you can skip the full board and go to the appellate, but then there's the appellate. When you go to the appellate, you have left the board. You're not dealing with us any longer. You've left us. We can't help you. We have nothing to tell you. We have no statuses. You've seriously left the board. Okay, that's pretty much the appeal process, but it is something that you do need to be cognizant of. Here is one of my favorite topics. Jen, what's a settlement?
Settlement is a Section 32 waiver agreement, and it permanently closes medical, indemnity, or both in exchange for a payment.
Well said. Thank you. She did not know I was going to ask her that. Okay, but listen, my friends. A settlement, you hear this term used regularly and casually. Here's what it really and truly is. A Section 32 waiver agreement. That is an agreement between a payer and a worker. And it's going to, as Jen perfectly cogently explained, it's going to permanently close either your medical care or your indemnity, lost wage benefits, or both. And you're going to get a payment now, and that's it. You're done. You've left the system. There's nothing anybody here can do for you for those elements that you have permanently closed. That is a settlement. Now, here's the thing that I think everyone needs to understand. Number one, you're not getting this just because you got hurt. This is a completely optional thing that the worker and the payer have agreed to engage in. So this is not just coming to you if you are a worker. There has to be a reason why you and the payer have agreed to do this. That's number one. And number two, we here at the board, we cannot compel one party or the other to do this, okay? We can't tell people to do this, or businesses, we can't, and we don't. Our role is limited to receiving the agreement. One of our legal staff, usually a judge, right now, although we are planning to get these done off calendar or away from judges by other attorneys. But anyway, the point for you guys is one of our legal staff is going to review the agreement and either approve it or reject it. The only time they're going to reject it is if it's legally unsound or if it's unconscionable, or there's or it has, it's legally unsound or unconscionable. Those are the reasons why it might get rejected. But other than that, it very possibly could be approved, and we are not involved in the negotiations in any way. Oh, and by the way, everything in all the payments in our system are tax-free. Okay, so we say that in the 101, but this would also be tax-free. If you're interested in this or you're practicing in this, there are some conditions we've announced over the years, but there are some parameters about 32s with respect to what can and may not be in the agreement. So I encourage you to visit our website, the Section 32 area, to check that out. And you're also going to have to watch the video if you're a worker. You have to watch that video before you sign this. But the good news is I wrote the script of the video. Okay, let's talk about our last topic, finding an attorney. You're a worker, you'd like an attorney. This is directed at workers. The payers know how to find counsel. This is for workers. You certainly may retain an attorney if you wish. You do not directly pay your attorney. Matter of fact, your attorney is only going to receive a fee if money moves towards you, the worker. And there are definite parameters around how much that fee can be. It's set in the law now. So how do you find an attorney? Well, we here at the board, we may not give you a name. We can't do that. But we can tell you where you can go. And they are right on screen. That first one, the New York State Bar Association. It's the Bar Association. That's the association of all the attorneys in the state. That's a really good source. You contact them either by phone or go to findalawyernys.org, not com.org, and you request a referral for comp. They'll give you 3 names. There's also an association of all the attorneys who represent injured workers with the unexpected name of the Injured Workers Bar Association. Well, you can go to them too. They'll give you several names as well. There's their phone. They are also injuredworkersbar.org. Okay? We here at the board on our website, we have a list of licensed representatives. These are people who are not attorneys, but they took a very, very rigorous exam and they passed it, which gave them a license to represent injured workers at hearings. We have the list on our website, and it's a pretty big list. Okay, so if you can't find somebody through method 1 or 2, definitely go check that. And then finally, we just want to call out to you. Remember we were talking about how you don't pay an attorney and attorneys get a fee from any money moving to you? Well, in a medical only claim, there's not going to be any money moving to you. So if you need help finding an attorney in that circumstance, we have a partnership with the Bar Association, the State Bar Association, to help find workers for you on a pro bono or free basis to represent you if you have a medical only claim and you need help. If this is you, visit nysba.org, select workers' comp, and fill in the form. Someone will contact you. Yes, we've come to the end of our very difficult content. Now we're at the fun stuff. You can follow us. These are our social media presences. We have so much content on YouTube, the fourth one down, including recordings of these webinars. So sometimes, Jen, people ask us for the slides.
Yes, we have several of those questions. So if you visit the board's website, and you scroll down to the bottom, you will see a page for our webinar recordings. This is there. We have several others as well. And we even have past recordings, so you can check out those too. But this specific presentation will be posted soon.
And we do so many other different types of presentations, don't we?
We do. We have paid family leave. That would be on the paid family leave website. But we also have Advocate for Business. We have recordings for payers, what providers need to know, CMS 1500, onboard, a range of topics. So you can find those all on the website too.
And you'll probably end up on that YouTube at some point. Oh, and we recently categorized them too by topic. So that was pretty cool. Shout out to Craig on that one. So now, why don't we put up the contact info from my office, and why don't we turn our attention to questions that have come in?
Yeah, so we do have many questions that have come through the chat. Give us a moment to take a look at these and we will get back to you momentarily. Okay, thank you for your patience. We'll get started here. Our first question is asking, as an employer, when is it advisable to offer FMLA to an employee who is out on workers' comp?
We read the question so that, we could be collegial and let you know that at this agency, we really can't give you that sort of advice. Yes, I also brought it up just so I could explain to everyone the difference between FMLA and comp, okay? Because this is a question we do get, and we do get this in the paid family leaves as well. So FMLA, the Family Medical Leave Act, is a federal law and a federal protection for workers where if the employer meets the conditions to fall under the FMLA, the worker's position must be kept open for 12 weeks. It is possible that you could be on workers' comp for 12 weeks or so, but we can't tell you when to invoke it or when not to. I can just give you a personal plea if you're an employer. Maybe, someone got hurt, furthering your economic interests. Maybe help them come back as well as you can. So that's how we're going to have to handle that one.
Okay, our next question here. In the case of a fatality, how can family get access to claim details?
Well, I'm so glad you asked that one. Number one, you can certainly go back to the Workers' Comp 101 and play the section on fatality claims that we talk about. Number two, you could go to the board's website under publications and look at the fatality fact sheet that we created. We actually created that at the start of COVID because COVID claims are payable under workers' comp, my friends, and that includes fatalities. How does the family get access to claim details? Well, here is the real explanation. When a worker is injured but still alive, the worker is known as a claimant. Okay, that's insurance industry jargon. You're a claimant. You filed a claim. Let's say that, there's a fatality though. So the worker is deceased. The family is going to file the claim, and it's going to be one person probably in the family who's going to be the claimant. So in the case of a spouse, a surviving spouse, it's a very easy example. The surviving spouse is going to be the claimant, and the claim may also include for payment children who meet the criteria, or dependents who are blind or disabled, but one of them is going to be the claimant. Okay, that's the person who gets the details. Cousin Mel from Iowa. No, I'm sorry. Cousin Mel from Iowa is not going to get details on this claim unless, for some reason, the actual claimant filled in a 110A form and said you may discuss with Cousin Mel. Okay, so it works very similarly to any other comp claim, and my office can be very helpful on these. You see the contact info there? If you have a legitimate reason to talk about a fatality claim, give us a call. We'll help you to the extent that we can.
Okay, thanks, Joe. Our next question is asking, wondering if the injured worker gets notified by the board of the option to complete the DB 450 Notice of Proof of Claim for Disability Benefits form if their claim has been controverted.
I believe the answer is yes, and I believe it's happening on the claimant information packet. I believe that mentions it. Everybody should be getting that. So the answer is yes. The context might be a little different. Like you might get the claimant information packet and you might not be controverted yet, so you're gonna have to remember it 2 weeks later when you get controverted. And it's also on some of our publications. So yes, we do. And if you want to spread the word, go on ahead.
Okay, our next question here, if you are 100%, if you are 100% disabled, are you obligated to be LMA? And if you are already permanently partially disabled, are you obligated to be LMA?
All right, these are two questions, and they're actually two very good questions. I'm going to give you a little more info than you thought you were going to get. Number one, if you're 100% disabled, are you obligated to look for employment? The answer is no. The first condition is temporary partial. Okay, remember that quiz we took where the person was at 75% and now the question came up? So that's your answer there. Now, if you're already permanently partially disabled, no, you are no longer obligated to seek employment. However, here is the big explanation. Until 2017, when the law changed, when this went into the law explicitly for the first and only time, before 2017, you could be asked to demonstrate employment while you were permanent partial. So those people who might have had their benefits stopped back then, you still need to reattach to restart your benefits. Also, let's say this year, your benefits were stopped because you were temp partial and you didn't demonstrate attachment, and then you converted to permanent partial, your benefits do not automatically restart. You will still have to demonstrate your labor market attachment.
Okay, our next question here. Are we required to send the carrier's report for rehabilitation within 30 days and the statement of rights within 14 days?
You should be sending the statement of rights, yes. The carrier report for rehabilitation, I will tell you truthfully, we are full disclosure here, my friends. I have no idea what that is. That is not an official board form, so I'm terribly sorry, but I don't know what it is. And it might be unique to your payer. If you wish to elaborate in the comments, feel free, and we'll get down to that. But for right now, we're going to go to the next one. And
Okay, our next question. Who brings the IME?
Okay, so I think when you say bring, I think you might be asking who sets it up, who picks the IME. So I'll just tell you everything I know about it, which is essentially this. The payer is going to ask its IME provider to schedule an appointment. So the doctor who's going to do the exam will be selected by them. Okay, so this is all happening between them.
And just want to say hello to our friend Tony. Hi, Tony. Um, Jen, let's go on. What else do we have, Jen? Well, yeah, FMLA is a federal law. Okay, we're just reacting to some comments here. And okay, I think that we're out of questions already. So what do you say? We should
Do you
probably keep it
wanna-
open another
Yep,
minute.
yeah, let's give folks another minute or two if you have just thought of something, if you're in the process of typing your question right now. We're gonna go ahead and just give you a couple minutes. While we're waiting for folks to enter their questions, I do want to point out, on the screen, you'll see the website for the board, and the Advocate for Injured Workers does have its own page. So if you go there, you can find a lot of additional resources, in addition to many of the things that Joe has covered, but I do want to flag that. There is a page specifically for the Advocate for Injured Workers on our website, and that is a great resource.
We do some videos too.
Do some videos as well, yes.
Okay, we've just got a question specific to, some animosity between the worker and the employer. Here's what I need to tell everyone just globally. It is possible to be a worker, to file a claim, and to not agree with the ultimate resolution. And so I will just apologize and say, I'm sorry, but if you don't agree with the ultimate resolution and if it has gone through the course, decision, appeal, appellate, there's really nothing we're gonna be able to do about that decision. Okay, that is the decision. We just got something. Let's see what we have here. Oh, yeah, go ahead.
Okay, our next question, if an employee has a workers' compensation claim from the city, is the New York State employer able to combine the cases if it is the same body part? Or should we file as a brand new claim? The employee worked for the city before and now works for the state.
Oh, okay. Allow me to maybe expand the question a little bit to make it more pertinent to everyone. Let's say you're a worker and you worked for one employer in 2010 and you hurt your arm. Okay. And then you changed jobs. Well, you're probably aware of the concept that says that original insurer from 2010, they own that claim. Okay. You can change jobs. The claim is still with that insurer. Now you have another job, another insurer, and you hurt the same arm again. Well, go to the doctor and get an opinion on whether this is a new and different injury that happens to be on the same body part, or whether it is an exacerbation or a re-injury of the existing, the previous injury that was taken care of on an existing claim. If you have exacerbated or re-injured an existing problem, oh, it's an exacerbation. Oh, thank you for typing that in. Okay, so yeah, it's the same claim back from 2010. All your care should be under that claim. So your new employer, they're not involved. It's going back to your original claim.
All right, folks.
Yeah, okay.
Yeah. Our next question, how do we as the employer handle their leave?
There is nothing specific in the comp system that says, okay, if the worker needs to go to a 2-hour appointment for healthcare for the comp, that you have to do this because it's comp. So in something like that, you would just use whatever paid time off options you have. If the worker, say, is going to be off of work now for a period of time because
the worker's back to 100% disabled because of the exacerbation, let's say, and you're a new employer, well, the worker could be receiving the lost wages under the comp, and then you, as far as your leave, I'm gonna hope that you're gonna be compassionate and you're gonna just put the worker on whatever leave that you have available. Okay, because this person needs some help. Yeah, okay.
All right, our next question. Does New York State have current rules that allow for lower cost medications, such as topical medications?
Well, I don't, topical could be expensive or lower cost. But the point is, I'm going to take your question is, do we have rules that allow for lower cost medication? Well, we have a formulary. So the formulary very possibly might have lower cost or generics, or it might not. It's going to depend on the particular drug that we're talking about and the treatment. So for part two, if you would like to talk in more detail about such a thing, contact the Office of the Medical Director. The Medical Director's Office, they're going to be very good on formulary topics because it's healthcare. And yeah, they can answer specific questions. In general, the more specific you can be, the better response you'll get from us.
That email address is mdo@wcb.ny.gov.
Thanks, Joe.
You're welcome.
All right, we'll give you another minute here if you have anything else. Other than that, there's at least one member of audience who will be watching the World Series tonight, apparently. We're hearing about the World Series, which is fine. It's a New York team and a former New York team. Okay.
All right, we have another question here. If an employee does not provide medical clearance from a doctor after a fall at work, can you force them to get one before allowing them to return to work if the severity is not obvious or significant?
Well, that's quite a question. I think that, well, I know in this agency, we have the authority to ask workers to attend a physical to prove fitness. I'm not certain actually in the broad world. I'm just not. I do know that if it's a union shop, very probably a collective bargaining agreement will have something to say about this. If it's not a union shop, I have to tell you, I'm not certain. And you are asking really a specific workplace question, which is very possibly outside of our jurisdiction anyway. It's not union, I'm hearing. Okay, if the employee does not provide medical clearance from a doctor. Okay, so I'm gonna recast this a little bit. Does not provide medical clearance from a doctor. All right, what does... All right, the employee fell at work, so the employee hopefully would get medical care. If the employee did not get medical care, then why are you supposing that the worker has some sort of a disability? I know you're not standing in the way of the worker getting medical care. So if the worker did get medical care, there's going to be a degree of disability. If it's 0% disability, that's a doctor saying this person has no disability. If it's 50% or 25%, well, there is some disability there. It is always possible for a worker to ask the doctor for restrictions, and then the doctor can write some restrictions that you can incorporate into the duties, and then you're possibly giving the worker alternative duty or light duty, which is a very far-sighted and enlightened thing to do. So try and work together on this one and try and make sure if the worker did see a doctor, there's going to be a degree of disability.
All right, thank you, Joe, and thank you to everyone for joining us today. Just a reminder, you can also sign up to receive workers' compensation news, including information on future webinars straight to your inbox. To sign up, visit the Workers' Compensation Board website, wcb.ny.gov. Scroll down to the bottom of the homepage and select Get WCB Notifications. We also distribute information via our social media channels, so please follow the board on Facebook, X, Instagram, and YouTube. We thank you all for joining us today and enjoy the rest of your afternoon.